Who appears? Thank you. Yes, please put your names on the record. Judgment on the application for leave to appeal. On 16 September 2019, the court granted an order declaring that the allegations that the respondent, Mr. Zuma, tweeted about the applicant, Mr. Derek Hanekom, were defamatory, false, and continued to be unlawful. Mr. Zuma was ordered to remove the tweet within 24 hours from all media platforms, including by deleting it from his Twitter account, and to tweet an apology within 24 hours. Mr. Zuma was also interdicted from publishing any statement that says or implies that the applicant is or was an enemy agent or an apartheid spy. For clarity and to avert any debate about the implications of the court order on Mr. Zuma's testimony at the Zondo Commission, the court added, quote, "The interdict in the preceding paragraph does not bar the respondent from testifying truthfully as he is required to at the Zondo Commission, at the Judicial Commission of Inquiry into the allegations of state capture, corruption and fraud in the public sector, including organs of state," unquote. The court awarded Mr. Hanekom damages, the quantum of which was referred to oral evidence for determination. Mr. Hanekom's request for a special order for costs was refused, and Mr. Zuma was ordered to pay Mr. Hanekom's costs, including the costs of two counsel. The matter was adjourned sine die. In this application for leave to appeal, Mr. Zuma's counsel advances the following main grounds. One, the statement was made in the context of a political debate, which, like all such debates, is heated and robust. Two, a reasonable reader, having regard to the statement, would not interpret or understand the statement to mean that the applicant was an apartheid spy. Three, in any event, the statement that the applicant was an enemy agent is true, as he himself conceded to have worked with the ANC opposition to topple his leadership. Four, the effect of the applicant's case and the court's findings justifiably limits the right to freedom of expression. Five, the effect of the court order is to limit the respondent's freedom of expression going forward, even in all other platforms and contexts. And six, the court's order is drastic and stifles political debate, unquote. On these grounds, counsel urged this court to find that another court would come to a different conclusion if it grants leave to appeal. Mr. Zuma does not invoke, quote, compelling circumstances, unquote, or any other provisions of Section 17 of the Superior Courts Act to ground this application. He has to convince this court that his prospects of success on appeal are, quote, not remote but have a realistic chance of succeeding. In this application for leave to appeal, it is important to bear in mind precisely what issues were before the court. At the commencement of the main hearing, the parties narrowed down the issues for determination thus, and I quote from my judgment, paragraph 11, "Neither the facts nor the legal principles are in dispute, as it is common cause that Mr. Zuma published his tweet. Proof of the act, publication, and intention are established. Wrongfulness is not only presumed but also conceded. That is, if I find that Mr. Zuma's tweet implies that Mr. Hanekom is an apartheid spy. If I do, as Mr. Hanekom suggests I should, then the application must succeed. If I find the opposite, then the application must fail. Reduced to this binary, the issue is a determination of fact or inferences from facts. Justification would not arise. However, Mr. Zuma reserves a right to justify his tweet as being true, fair comment, or falling within the limits of the right to freedom of expression in Section 16 of the Constitution." What the case is about is the natural or ordinary meaning of Mr. Zuma's tweet in the context. Would a notional, reasonable a right-thinking reader with normal intelligence understand Mr. Zuma's tweet to mean that Mr. Hanekom is an apartheid-era spy acting against the ANC. It is common cause that the posts on social media do not represent the reader's understanding, do not represent the reasonable reader's understanding, but may go to assessing the quantum if that arises. Importantly, what this dispute is not about is whether, as a fact, Mr. Zuma is an apartheid spy. Sorry, I beg your pardon. Whether, as a fact, Mr. Hanekom is an apartheid spy. Nor does it call for a value, moral, or political judgment about whether Mr. Hanekom's or Mr. Zuma's understandings of the politics within the ANC should prevail. As a dispute presented for resolution through litigation, legal principles must apply. Continuing with that quotation, paragraph 13, the issue boils down to interpreting Mr. Zuma's tweet in the political context in which he published it. As an interpretive exercise, it is possible to resolve the merits on the pleadings. I am indebted to both counsel for narrowing down the issues thus. After summarizing the case for each litigant, I analyzed the phrase known enemy agent in isolation, then in the context of the entire tweet, and finally in the light of the reference in it to the Commission. I preface my analysis of Mr. Zuma's tweet with a brief description of the political context in which this litigation presents. I quote extensively so that the litigants, quote, speak, unquote, for themselves, and their, quote, voices, unquote, and the tone in which they choose to express themselves in their affidavits are not diluted or misrepresented by my paraphrasing, unquote. This is the context in which counsel for both parties in the main application invited the court to interpret Mr. Zuma's tweet. Neither party wished to lead evidence nor contest the veracity of the factual disputes in the affidavits, at least not at that stage. Mr. Zuma reserved his rights then and continues to do so now to make statements about Mr. Hanekom at the Zondo Commission and elsewhere. The case before the court at the main hearing and in this application for leave to appeal remains the interpretation of Mr. Zuma's tweet. All other grounds of appeal are peripheral to this central question. Mr. Zuma's tweet reads as follows, I quote, "I'm not surprised by at Julius S. Malema revelations regarding at Derek Hanekom. It is part of the plan I mentioned at the Zondo Commission. At Derek Hanekom is a known enemy agent," unquote. Counsel for Mr. Zuma accepts that the tweet is open to several interpretations. If it was unambiguous, the parties would not have sought the court's opinion. As reflected in the agreement I quoted above, the court's opinion had to rest on the interpretation that an ordinary reader, a reasonable, right-thinking person of average education and normal intelligence. Neither Mr. Hanekom's nor Mr. Zuma's interpretations of his tweet are necessarily the interpretation of a reasonable reader. Of the possible interpretations, counsel for Mr. Zuma submits that a reasonable reader would interpret the tweets to mean that Mr. Hanekom is an enemy of Mr. Zuma and the ANC because he, quote, sold out, unquote, or doubled both the ANC, unquote, and Mr. Zuma when he acted to have him removed as president. Furthermore, Mr. Zuma chooses his words very carefully. Therefore, if Mr. Zuma intended to call Mr. Hanekom an apartheid spy, he would have done so. Nowhere in his tweet or in his affidavits does he say that Mr. Hanekom is an apartheid spy. The following statement in Mr. Zuma's affidavit conveyed a metaphor, in brackets, simile, and not a statement of fact. Quote, "By assisting the political enemies with information to weaken the ANC and topple its leadership, Hanekom acted as an apartheid enemy agent, my underlining as an apartheid enemy agent. The court agrees with counsel that Mr. Zuma chooses his words carefully. Equally, if Mr. Zuma intended to say that Mr. Hanekom is an enemy of Mr. Zuma and the ANC, he would have done so in clear and unambiguous terms. He would have said just that. Had he done so, he would not have aggrieved Mr. Hanekom. Mr. Zuma's interpretation does not account for information in the public domain that the ANC caused Mr. Zuma to resign as president. Mr. Hanekom supported this resolution of the ANC. As counsel observes, Mr. Hanekom is, quote, proud, unquote, of his role in having Mr. Zuma removed as president. Nor does Mr. Zuma's interpretation account for the words known enemy agent, unquote, taken singularly, collectively, in the context of his tweet, his affidavit, and his affidavit. The court refers to its main judgment, in which it expatiates on all these dimensions in its interpretation of his tweet. Furthermore, Mr. Zuma's interpretation, if Mr. Zuma's interpretation is to be accepted, it does not explain why he chose to respond to Mr. Hanekom's account of his history and personal sacrifices for the liberation struggle as an ANC member. Mr. Zuma could have dismissed Mr. Hanekom's evidence, this evidence of Mr. Hanekom, as irrelevant and undeserving of his response, because his tweet was unrelated to the past, but referred to Mr. Hanekom's recent role in acting to remove him as president. Instead, Mr. Zuma gratuitously insults Mr. Hanekom as follows, I quote, "His entire life as a duplicitous, two-faced person is an embarrassing lie," unquote. His entire life and conduct are the antithesis of an activist and the new cadre that the ANC seeks to develop, unquote. Quote, "Only Hanekom can attest to his true role within the SADF or the ANC, full stop. He knows which of the two he was deceiving. This is not for this court to determine at this stage," unquote. And, quote, "I note that Hanekom's affidavit is replete with his protestation and denial that he was ever an apartheid spy during the anti-apartheid struggle. His protestations, though understandable, are misplaced and premature, as I have not yet mentioned him as an apartheid spy," unquote. These embellishments by Mr. Zuma fortifies the court's interpretation. As a man who chooses his words carefully, Mr. Zuma uses innuendo to further his ends. Even if it is possible to stretch the interpretation to conclude that readers may arrive at the interpretation that Mr. Zuma seeks to place on his tweet, it is not a probable or, quote, dominant impression that readers would have been left with, unquote, after reading the tweet. Nor is it a probable interpretation that reasonable readers would arrive at. Moving on to the other grounds of appeal, it must be emphasized that the court was guided from the outset by counsel for both parties. The issue in dispute turned on the interpretation of the tweet. The court was not tasked with determining the truth of the contents of the tweet after determining its interpretation. Consequently, the question of the truth of the contents of the tweet did not arise. In these circumstances, it is difficult to understand why counsel for Mr. Zuma submits that, open quotes, the court demanded that Mr. Zuma prove that Mr. Hanekom was a spy, unquote. The finding that the tweet was false was consequential upon the finding made at the express invitation of the parties that the tweet was defamatory. Furthermore, without evidence, which the parties elected not to lead, the tweet was unjustified in the context of this case. As counsel for Mr. Zuma correctly points out, Mr. Zuma could not be expected to prove the truth or justify his tweet on the court's interpretation, which he rejects. Nor was it necessary to prove the truth of the interpretation that Mr. Zuma places on his tweet. His interpretation, based on Mr. Hanekom's admission that he supported the decision of the ANC to remove Mr. Zuma, is not the cause of dispute. Cause of this dispute. In these circumstances, the issue of truth and justification did not arise. The constitutional grounds of appeal also do not arise. The court cannot undertake a balancing of the right of Mr. Hanekom to dignity with Mr. Zuma's right to freedom of expression unless Mr. Zuma accepts that Mr. Hanekom's dignity was impaired in some way, or could have been impaired in some way. Mr. Zuma's interpretation of his tweet does not impair Mr. Hanekom's dignity. Furthermore, the parties chose not to lead evidence about these rights in the main application, as important constitutional rights, much more than a passing reference to the relevant constitutional provisions, is required. In no way can or does the court unlawfully constrain Mr. Zuma's right to freedom of expression in future, nor does it stifle political debate. Going forward, each expression has to be assessed on its own merits in the context in which it occurs. This is trite. Hence, the clarification in the order in the main judgment that Mr. Zuma's testimony before the Zondo Commission is unaffected by the order in this case. For now, Mr. Zuma's tweet must be assessed on the evidence and arguments proffered in this case. Turning to the criticism raised in the heads of argument submitted for Mr. Zuma by the court opening its judgment to the quotation of Oliver Tambo, the submission reads as follows. When the judgment is considered in its totality, one may be forgiven to think that the court considers or implies that the respondent considers the respondent as a wedge driver and has a poisonous tongue. We respectfully submit that the court was not required to make a political determination or analyze the ANC politics. The political pronouncements of the court are highly unfortunate. We implore upon this court to desist from getting into that space. We do, however, have confidence in this court and its impartiality. We trust that this was not making political determination. The defamation dispute between the parties arises in the context of a political conflict that falls outside the remit of this litigation. This is common cause. The pleadings are littered with references to the political context. It would be a misdirection to have ignored this context. The reference to wedge drivers arose during the hearing in the main application in the context of the parties as veteran members of the ANC fingering each other with all kinds of dishonorable conduct. That this litigation falls typically in the category of lawfare is uncontested. It would be a misdirection and false to pretend otherwise. The consequences of ignoring the political context lies in the risks and rewards for the remedies that courts might prescribe. Therefore, it remains appropriate to remind both parties of the caution that their leader sounded for their organization about wedge drivers. While that terrain is off limits for this court, it falls squarely within the business of the parties. Taking a cue from counsel for Mr. Zuma, the court acknowledges his observation that neither party would have approached the other directly through their organization or a third party to clarify Mr. Zuma's tweet. However, counsel was pessimistic about whether these protagonists would ever find a mutually acceptable resolution of their differences. The court takes the opposite view. If South Africa could negotiate itself out of the quagmire of apartheid into a vibrant constitutional democracy, the starting point should be that no conflict is unsolvable. If successful, such an approach could shift litigation beyond dispute resolution and conflict management to problem solving. How this can be accomplished in this conflict is for the litigants, those advising them, and their political party to resolve. That is, if they so choose. Emphatically, I repeat emphatically, this is not a directive for the court, directive of the court, but an option for the parties and their advisors to consider. The court's function is limited to determining the dispute on principles grounded in law. This is what the parties seek in this application for leave to appeal. Accordingly, in the opinion of this court, an appeal against its judgment of 6 September 2019 would have no reasonable prospects of success before another court. Consequently, the application for leave to appeal is dismissed with cost. I hand down the order. The reasons for judgment will be edited and distributed in the next few days. We're adjourned.